Good afternoon, everyone.
Good afternoon, Your Honor.
Good afternoon, Your
Good
Honor.
afternoon, Your Honor.
Yeah.
Good afternoon.
All right, is everybody ready to start?
Yes, I believe so.
Yes. All right, good afternoon, ladies and gentlemen. My name is Regina Mincy, and we're going to begin our Fulton County State Court Expedited Accusations calendar. This is a calendar for cases in which individuals have been recently arrested and charged with certain misdemeanor offenses. Soon after their arrest, the Fulton County Solicitor General's office has already accused the cases of the offenses brought against them, and the cases have been bound over to the Fulton County State Court. Nevertheless, this will be the defendant's initial appearance before a state court judge. So we're going to address several matters, including bond, possible arraignment, and a possible plea offer if one has been made by the state at this juncture. I want to begin and advise everyone that this whole entire proceeding is being recorded as well as live streamed on YouTube. I want to also remind the defendants on this calendar that you do have a right to have an attorney at this proceeding, which most of you do. I want to also remind you that you have a constitutional right to remain silent. Anything that you say about the facts or occurrences regarding this case should be limited and not spoken about at this point. Your attorneys will guide you through it and instruct you on what you need to say or not to say. So follow the instructions of your attorney. We'll get ready to start. Which courtroom are we starting in, deputies?
Two.
Two, okay.
Good afternoon, Judge Mincy. I
Afternoon.
currently don't have a calendar at the moment. We're getting that, but we have Mr. Devon Harris in front of you. Okay.
Number 7.
No, we don't live in it. She live in her own house and I live in
All right, that's position 7. This is case number 22 CR 005696A. Devon Harris, you're charged with 1 count of simple battery family violence. The offense date is August 25th, 2022. Pretrial?
Check your chat.
Oh, okay. Got
Right. That's what the fugitive one is for. 28 total. Last arrest was 2020, failure to appear. All this history come out of Kentucky. Before that was 2017. It says non-payment of fines. 2017 FTA. 2016 cruelty to animals, 2nd degree. 2016 failure to appear. Another 2016 FTA. 2011 trafficking marijuana. I'll leave it at that. This is first Georgia arrest.
Okay. All right, I forgot to ask Ms. Bridgewater, what's our SAP date?
It's going to be September the 8th.
Okay. All right, state, are you ready?
Yes, Your Honor. Good afternoon. Your Honor, this incident occurred yesterday. Officers responded to 1996 Campbellton Road Southwest, Apartment 203, in regards to a dispute call. The dispatcher heard loud yelling while notating the call, and upon the officer's arrival, he saw a man with no shirt on who had a cut on his arm. It was bleeding. He asked the male, who was later identified as the defendant, how he got it, but he said he got cut on the door frame to his apartment when he was trying to leave. He told the officer that as he was attempting to leave, his wife, who's also the victim here, and the cross defendant, that she had thrown a plate at him. I believe it did not make contact, but the wife said that she only began to hit him because he pushed her, because she was trying to get her car keys from him. And that's when the altercation started, when he actually pushed her. He does have, the officers ran his name, and he does have a hold out of Kentucky that they are going to extradite for. Based on the history, Your Honor, the state is asking for a $2,500 surety bond, and to release to that Kentucky hold. No further contact with Miss Ebony Gill, and stay away from that incident location. No alcohol, drugs, or weapons. We're asking for that simply because he has quite a few FTAs. So and he has an extensive history, even though it's not in Georgia. There's a risk of reoffense, as well as a failure to respond to legal process, Your Honor. And so we feel as though the surety bond is more than appropriate in this case. Nothing further.
All right, you mentioned a surety bond, that you know about the extra addition back to Kentucky. And so we know that that's going to happen, correct?
It is supposed to happen. I will defer to Supervisor Walker on that. We did discuss a signature bond, however.
Good afternoon, Your Honor. I'm here, but it's my understanding that he would have to post a bond before he would be able to be transferred.
Okay.
Really, that's my understanding.
Right, it's exactly what I was gonna ask you about. Okay. That's fine. All right, whose case? Ms. Gant,
Yes, Your Honor, good afternoon.
good afternoon.
Your Honor, Mr. Devon Harris is 42 years old. He has been in the Atlanta, Georgia area for 6.5 years. He is married and has been so for 1 year, and with his wife, he shares 5 children, ages 17, 18, 16, and a set of twins, ages 13. He completed high school. He also has bachelor's degrees in business management, associations, and importing, exporting. He also is a certified in culinary arts. He is currently a shift leader at Cracker Barrel. He has been in that position full-time for the past 5 months. Your Honor, my client disputes the allegations. He denies being the primary aggressor. In essence, he was basically trying to remove himself from a situation that was escalating. That said, he still wants to have contact with his wife. I did speak to Miss Ebony Diana Gill on the telephone. She told me that she would be on the Zoom call to inform the court of her wishes. I am requesting a signature bond on Mr. Harris's behalf. I believe that that will facilitate his ability to be released to respond to the matter in Kentucky. In the alternative, if Your Honor determines that he's ineligible, I would ask for a bond of no more than $1,000 for this misdemeanor offense, in which there is a question about, who really is the primary aggressor here. We are opposed to the no further contact and the stay away orders, and if Your Honor imposes such, we would ask for a one-time law enforcement escort and third-party transfer. Thank you, Your Honor.
And I see that Ms. Gill is on the Zoom. Ms. Gill, do you wish to address the court? Ms. Gill, are you still with us?
Yes, I'm here, Your Honor. I really just wanted to listen in. I really didn't want to speak.
Okay. If you are, I have to see you, but if you don't, then that's fine. It's up to you.
Yes, ma'am.
All right. So you do not want to address the court?
I don't.
Okay.
Your Honor, if I may ask Ms. Gill a question.
Ms. Gill, can you turn on your camera? Are you able to do that?
Absolutely.
All right. I'm going to swear you in. Can you raise your right hand for me? Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, I do.
All right. Thank you. Put your hand down. Go ahead, Ms. Gant.
Good afternoon, Ms. Gill. I am asking specifically whether or not you would like to have contact with your husband.
Yes, that's fine.
All right. Thank you, Your Honor. That is the extent of my questions.
All right. Ms. Backus, do you have any questions?
Yes, Your Honor. Our victim witness advocate did speak with Ms. Gill as well. And she did state that she wanted contact. However, we're aware of cycles of violence, but also she said that they needed a cool down period. And that, she didn't want him back there right this moment because they needed to cool down. So at the end of the day, Your Honor, still with the violent nature of the offense, the surety bond is still, the state's position is that it's still an appropriate ask, nothing further.
All right. All right, I'm going to order the $2,500 surety bond. I'm going to order no further contact with the victim, Ebony Gill. I'm going to order stay away from 1996 Campbellton Road Southwest. I'm gonna order a one-time police escort to retrieve any personal belongings. And I'll order third-party transfer if visitation is allowed with the children. No drugs, alcohol, or weapons while on bond. And I think that would,
Just FYI, Your Honor, I don't believe they share children.
okay, I heard.
5 children, Your
I
Honor.
think- Yeah, I think Ms. Gant asked for that.
Yes, 5 children. My client informs me there are 5 children that are product of the marriage.
Are they his biological children?
They're married, so they are his children by marriage.
Okay.
Ms. Gill? you still
Yes.
With me? Are any of the 5 children the biological children of Mr. Harris?
Not biologically.
Did he adopt any of them?
No, ma'am.
Okay.
Through marriage, through marriage, but that's about it.
Well, if you allow any visitation, since he has a no further contact order with you, it must be facilitated by a third party, not yourself, so that he doesn't violate his conditions of the bond right now. And so that'll be up to you, but you need to have a third party to facilitate it. All right?
Okay, can I just say something?
Maybe, maybe not. It has to be real short. I'm moving on to the next case because I've already given my ruling, but what would you like to briefly state?
Understood. I'll just let that be. Thank you.
All right, thank you.
Thank you, Your Honor.
Next case.
Position 9, Ms. McClinton.
Case number 22 CR 005698A. Is it Lenitra McClinton, charged with lauder and prowling? Offense date is 8/25/2022. Retrial.
11 total. 2008 arrest out of Louisiana for aggravated battery with dangerous weapon. The Texas was a juvie. She got a probation warrant out of Gwinnett. The last arrest was 2019 probation violation Gwinnett. Another 2019 probation and another one. She was arrested for sale of marijuana. That was a conviction. 2019 trespass. 2019 possession of cocaine, criminal trespass, first offender. 2016 public order crime conviction. That's it.
Okay.
Your Honor, this incident occurred on the 25th of this month. An officer was dispatched to 369 McDaniel Street Southwest, Unit 2319, to investigate an individual actively breaking into one of the units on the property. Upon arrival, the officers saw an individual matching the description given from the call on the balcony of the unit, actively breaking into the unit. So the officer immediately detained the person who was later identified as the defendant and asked why she was breaking into the unit. She told the officer that a male by the name of Levi had her belongings, but when the officer spoke with the property manager, Ms. Shamika Hardy, she said that that wasn't the case because that was actually a vacant and unoccupied unit. Your Honor, based on the history and the numerous probation violations, the state is requesting that there's a $5,000 surety bond in place. We're asking that remain in place, stay away from that incident location, and no alcohol, drugs, or weapons while out on bond. Nothing further.
All right, what's the incident location?
It is 369 McDaniel Street Southwest, Unit 2319. But I would ask that they stay away from that location completely, off the entire complex.
All right. Ms. Kim?
Yes, Your Honor. Ms. McClinton is 30 years old, and he's been here about 20 years, and he has 4 children, including newborn baby that right now her mother is taking care of. She's a single mom of 4 minor children, and she does not have a child support yet, and she has not had employment. Her education was up to 9th grade in high school. She is residentially challenged right now, so her kids are staying with her mother, but she is not actually staying with them. We would like to request for a signature on bond for this, and yet, if Your Honor is not inclined to give him a signature on bond, please note that she cannot go anywhere. She has to go to Gwinnett County after this. We would like to request maximum $500 good bond. Thank you.
So she has a hold for Gwinnett.
Yes, Your Honor.
Yes, Your Honor, Lawrenceville.
All right. I will leave the $5,000 surety bond in place. No drugs, alcohol, or weapons while on bond. And a stay away from the apartment complex at 369 McDaniel. I didn't hear a name of it, but I'm assuming it's.
I didn't get a name, Your Honor. I could look it up on Google if you want me to.
Well, I'm going to say 369 McDaniel. I can't say the whole McDaniel Street, or I can't say this group of apartments, because what I suspect is there's a lot of apartments on McDaniel Street. So if you give me a name, that'll be better.
1 second.
It's the Villages at Castleberry Hill.
Okay. Villages, Castleberry
Castleberry.
Hill. Thank you, Mr. Walker. So we're going to order stay away from the Villages at Castleberry Hill. And no drugs, alcohol, or weapons while on bond, except for anything prescribed to you, Ms. McClinton. All right, counsel, anything else I need to take up?
Nothing further, Your Honor.
All right, thank you. That concludes
you.
this case. Uh-huh.
Next, we have position 2, Mr. Barnes.
This is position 222 CR 005693F. Daquan Barnes, you charged with 1 count of battery family violence. The offense date is August 25th, 2022.
Also, Judge, they have a guest in the gallery.
Oh, okay. Let's see who that is.
No, that's just a visitor for Mr. Barnes.
Oh, okay. I'm sorry. I was thinking something different. But it's someone that doesn't want to testify. I'm assuming they're just listening in.
No, they're just here on his behalf.
Okay. All right. Go ahead, Ms. Cartarello.
Good afternoon, Your Honor.
Afternoon.
For the battery family violence, the state is asking for a $4,500 surety bond. The conditions is no contact with the victim, Miss Joanna Martinez, to stay away from the incident location at 4026 Spring Creek Lane. Spring Creek is 2 words in Sandy Springs. A one-time escort, 1-day anger management, no drugs or alcohol, no weapons, and no new violations of Georgia law. Your Honor, this incident occurred on August 25th, 2022, which was yesterday, at the incident location 4026 Spring Creek Lane. This defendant poses a significant threat and danger to victim Joanna Martinez under OCGA 17-6-1. Victim Joanna Martinez stated that the defendant Daquan Barnes got irate and began hitting her in the face with opened hands. The defendant's actions against Ms. Martinez caused bruising to her chin and cheek area. This defendant also poses a risk of intimidation of Ms. Martinez. Ms. Martinez advised the officer that the defendant is her boyfriend and the two have lived together for 6 years. Ms. Martinez advised the state that this is not the first time the defendant has been physically violent with her, but this is the first time that she has called the police. Ms. Martinez also told us she fears the defendant when he is angry. Victim stated that she filed for a TPO yesterday, and the victim wants no contact, a stay away from the residence, and a one-time law enforcement escort. Your Honor, the defendant was arrested and all these events occurred in Fulton County, Georgia. As far as flight risk and the risk of reoffending, this defendant is also being held on a $2,100 surety bond imposed by Judge Richardson and in a bench warrant issued by said judge on May 26, 2022, due to the defendant's failure to appear. This is case number 20 CR 003673 F as in Frank. This is a DUI less safe case, Your Honor. The offense date of July 20th, 2019, and was filed on June 15th, 2020. It's on a dormant status. The defendant failed to appear to his plea and arraignment before Judge Richardson on May 20th, 2021, and also FTA to his arraignment on May 25th, 2022 before Judge Richardson. Your Honor, he also poses a risk of reoffending. He has 4 cycles on his record, Your Honor, and he just FDA'd yesterday, Your Honor, in Fulton County. So for the reasons already stated, we do feel $4,500 surety bond is more than reasonable for this matter. Nothing further.
Okay. Ms. Scant?
Thank you, Your Honor. Mr. Daquan Barnes is 30 years old. He has been in the Atlanta area for 9 years. He has family here, including his mom. Your Honor, we are unopposed to the stay away and the no contact orders. My client informs me that he does not want any contact with Ms. Martinez. We are unopposed to the law enforcement escort. Mr. Barnes completed high school. He also has some college where he studied criminal justice. He is currently employed at EPI Breads. He has been in that full-time position for the past 2 years. Your Honor, my client denies the allegations. He states that this is basically a total fabrication on Ms. Martinez's behalf. And if I just may address the FTAs, Your Honor, we do understand that ultimately it is Mr. Barnes's responsibility to keep the court apprised, but he expressed to me that there was some genuine confusion on his part as to where he should, to which court or which to where he should address that, because he states that this matter initially started in Alpharetta, then of course was transferred, and he clearly was not clear about where he needed to send his information. So the FTAs on his part were not intentional. I am requesting a signature bond. He is recommended for a signature bond. If Your Honor determines for any reason that he is ineligible, I would ask for a bond of no more than $1,000. And again, we are unopposed to the no contact and the stay away conditions and would ask for the law enforcement escort. Thank you.
And Your Honor, the victim is on the Zoom hearing. If I'm not sure if she wants to speak.
And Your Honor, if the complaining witness would like to speak, I would ask that she limit her testimony to contact.
Your Honor, the victim actually does not want to speak. I just heard from our victim advocate, Your Honor.
Okay, we appreciate your time. All right, I will go ahead and rule then. I will grant the $4,500 surety bond. There will be no drugs, alcohol, or weapons while on bond. No further contact with the victim, Joanna Martinez. Stay away from 4026 Spring Creek Lane, Sandy Springs. And a one-time law enforcement escort to return to the property, retrieve any items if Mr. Barnes gets out on bond. And no drugs, alcohol, or weapons, and I believe that would be it.
What was that bond?
$4,500 surety bond.
All right.
What's your breakdown, Judge?
I only have one charge on my calendar. Is there a second one?
Okay. Okay, thank you.
No. All right. Ms. Tartarello, you only have one charge on position 2, Barnes?
That's correct, Your Honor.
Okay. All right, that'll conclude this case. If there's no other questions.
Thank you, Your Honor.
Mhm.
Position 10, Reynolds.
This is case number 22 CR 005700E. Reynolds, you're charged with 1 count of willful obstruction of a law enforcement officer, 2nd count possession and use of drug-related objects, and a 3rd count of tampering with evidence, all with the offense date of August the 3rd, 2022. Pretrial.
Your Honor, what position number is this?
10 should be, is this Nicolas Reynolds?
Yes, Your Honor.
Okay,
Position number 10.
okay.
Judge, you waiting on me?
Yes, sir.
Oh, 7 total. Last arrest was 2018 burglary in the first. That was a conviction. 2016 probation for burglary. He was convicted for possession of tools, criminal attempt to commit a felony in 2016. Another burglary conviction along with the obstruction, 2016. And another burglary, criminal damage to property, 2015. Yeah, he a burglar, serial burglar. That's all I can tell you. He went to felony earlier. They dismissed the charge. Statute of limitations, from what I was told. That's it.
Okay. All right, Ms. Duncan.
Good afternoon, Your Honor. This incident did occur at the Shell Food Mart located at 244 Cheshire Bridge Road Northeast. In this incident, officers responded to a criminal trespass call at that location. While they were there, it was not related to this defendant, but however, while there, the officer, while in his marked vehicle, observed the defendant in this case holding in his left hand a glass pipe and a butane touch lighter in his right hand. And the officer walked up to him to stop him from taking any further action to use the pipe. And when he reached out to stop him, the defendant recoiled his hand and took off running. Once the defendant took off running from the officer at that time, he took the pipe that was in his hand and shattered it on the ground. Officers were eventually able to make contact with the defendant, and he was arrested after that. And there was an attempted use of taser because he would not stop running. However, it made contact with his clothing and not his personal body. The state has a concern about risk of reoffense here. The defendant does have a previous obstruction conviction, so the state is going to be requesting, and we have some concerns about the likelihood to respond to the legal process. Since I did see a probation violation in 2016, the state is going to be requesting a $2,000 total surety. That's $1,000 on the obstruction and $500 for the tampering and $500 for the possession of drug-related objects. Nothing further from the state.
All right. Ms. Kim.
Yes, Your Honor, Mr. Nicolas Reynolds. He is 25 years old and he has been here in Georgia for all his life. He has his mother residing here in Georgia. However, he does not have any other family members. He has been working as a dishwasher or, bar at the restaurant mainly. And his education is GED. We would like to request for a signature on bond, and yet, if Your Honor is not inclined to give him a signature on bond, we would like to request for maximum $750 good bond, $250 for each. Thank you.
All right, I'm going to issue the $3,000 surety bond. And that will be the 2,000 on the obstruction, 500 on the misdemeanor, I'm sorry, 500 on the possession of use of drug-related objects and 500 on the tampering with evidence. So that'll be a total of 3,000. I'm gonna issue a stay away from the Shell Station at 244 Cheshire Bridge Road. No drugs, alcohol, or weapons while on bond. And I think that will conclude the matter. Anything else under you take up, counsel?
Nothing further, Your Honor.
Okay.
Position 6, Hamilton.
Come on, let me go. For real. Ain't loud on you, man.
This is case number 22 CR 005697C, Marie Hamilton. You're charged with 1 count of willful obstruction of a law enforcement officer, 2nd count of criminal trespass and damage to property, and a 3rd count of criminal trespass, all with the offense date of August 25th, 2022.
6 total. Last arrest was 2017, simple battery conviction. That was in Fulton County. Another 2017 simple battery conviction out of Chambly. Got a 2014 simple battery conviction. 2013 simple battery NOD. So she's not recommended based on this violent history.
Okay.
Your Honor, there's already a $2,000 surety bond in place, 1,000 on the first count and 500 on the remaining 2 counts. The state is asking for that to stay in place. We're also asking for no further contact with the victim, who is the defendant's mother, Patricia Hamilton, and a stay away from the incident location of 851 North Avenue. 1-day anger awareness, no alcohol, drugs, or weapons. This incident occurred yesterday when an officer responded to that incident location. Upon arrival, another officer was on the scene with the defendant who he had detained. The officer had been flagged down by the mother, and it appears some other people, to help with an irate female. The officer witnessed the female the defendant take a chair and break the window. And upon attempting to get the defendant inside the vehicle, she attempted to bite one officer and was kicking at both officers. One officer did sustain visible marks from the kick. And Miss Patricia Hamilton did say that her daughter has been given multiple trespass warnings from the location, and that she had already broken out all of the windows at the house or the location in last month. And so based on the history, she doesn't have a simple battery this time, but she's got a violent history. So breaking windows, all the windows 1 month, and this month we have serious concern about the violent nature of the offenses, as well as risk of reoffense, Your Honor. And so we are asking for that surety bond to remain in place. Nothing further.
All right. And this is Ms. Gant's case.
Yes, Your Honor. Thank you. Miss Marie Hamilton is 30 years old. She has been in the Atlanta, Georgia area her entire life. She has family here, including a sister and a brother, and of course her mother. Your Honor, Ms. Hamilton completed high school. She is currently employed at AFEX. She just obtained this position about 2 weeks ago. She's still on probation. She's missing work today, and she certainly may lose her job. She does not have the means to pay anything toward bond, nor does she have any assistance. She denies the allegations, and while I acknowledge my client's history, she has remote convictions for violence to people. The offenses here today, of course, for which she's presumed innocent, there is no allegation that she offered any violence to any person, Your Honor. So I would ask that you take that into consideration. I am requesting a signature bond. If Your Honor determines that she's ineligible, I would ask for a bond of no more than $1,000. And the breakdown would be for the willful obstruction of law enforcement officers, 250, criminal damage to property, 500, and 250 for the criminal trespass, for again a total of $1,000. She does not want any contact with her mother. And as far as belongings, she informs me that she does have some clothing at the incident location. However, she declines a one-time law enforcement escort. She will ask her sister to retrieve her belongings for her. Thank you, Your Honor.
All right. Let me go ahead and order a $2,000 surety bond, 1,000 for the obstruction, 500 for the criminal trespass, and 500 for the damage to 500 for the criminal trespass and damage to property, and then a 500 for the straight criminal trespass, for a total of $2,000. No further contact with the victim, and that was Patricia, her last name Hamilton.
It is, Your Honor.
Okay. And stay away from 851 North Avenue. And no drugs, alcohol, or weapons while on bond. All right, anything
you, Your
else,
Honor.
counsel?
Thank you, Your Honor.
Okay.
We have number 8, Mr. Heron.
Your Honor, I do apologize for not making this announcement at the beginning of court, but I did send a message to the host. Mr. Heron is hearing impaired, and I have not had the opportunity to interview him. I am requesting to be placed in a breakout with him and the sign language interpreter so that we may complete his interview to be able to proceed with this bond hearing.
Excuse me, but it's my understanding that we're still trying to get an interpreter.
Okay, I thought that I read in the chat that one had been secured. My apologies.
So we don't have one available today, Judge. We may have to reset this to tomorrow, see if we can get someone tomorrow. We have to go to administration across the street to request anybody outside of Spanish interpreter.
May I propose in the alternative, Your Honor, that I still be placed in a breakout with Mr. Heron to see if I may be able to successfully interview him. And then I understand that the court has the ability to enable a live transcription so that we can continue with the hearing after I obtain information from him.
Okay. I guess if the jail can accommodate us. So are we going forward with this or not then?
I would at least appreciate the opportunity to try to see if he is able to hear me and understand, or to hear me. I don't doubt that he can understand.
Right, can Ms. Gant call Mr. Heron to speak with him? Deputies, are we able to do that?
We can try. We can try. Give me 1 second.
Okay.
Judge, can we go ahead and continue on in courtroom 2 with position 1?
Okay.
Actually, if Ms. Gant is gonna be, I'm gonna have to do Mrs. Kim cases. So go ahead and have a seat. That's actually.
Position 1 is
Actually, no,
actually
position 1 is a conflict. That is correct. Thank you, Ms. Kim.
no problem.
Is that your case, Mr. McLeod? Oh, you're muted. Still muted. I can't hear you.
Position 1 is my case, Your Honor.
Okay. So deputy, that was a yes or no? We're doing one, position one?
Judge, we doing number one.
All right, is it Teresa Barber? Okay, and this is case number 22 CR 005692A, charge of one count of criminal trespass. The offense date is 8/25/2022. Is it pretrial?
First arrest. That's what I had.
Okay. All right, Ms. Tartarella?
Yes, Your Honor. For the criminal trespass charge, we're asking for the $1,000 surety bond already in place to be increased to a $3,000 surety bond. The conditions is no contact with the victim, Valerie Newkirk, to stay away from the incident location at 2045 Allison Court Southwest in Atlanta. 1-day anger management, no drugs or alcohol, no weapons, and no new violations of Georgia law. Your Honor, this incident occurred on August 25th, 2022 at the incident location of 2045 Allison Court. This defendant poses a significant threat and danger to victim Valerie Newkirk's property. Defendant Teresa Barber used a hammer as a weapon and intentionally damaged the rear windshield of victim Valerie Newkirk's vehicle by using the weapon to break Miss Newkirk's property without her consent. The cost of the damage was $300. The defendant was arrested, and all these events occurred in Fulton County, Georgia. Your Honor, we spoke to the victim. She stated that the defendant is a friend of her sister's. She also stated that she was visiting her aunt and sister at their apartment that day. The victim stated that she walked outside and the defendant followed her and started yelling and cursing at her, and that the defendant grabbed a metal pole and busted out the back windshield of her car. The victim stated that the defendant also lives in the same apartment complex as her aunt and sister. And I believe, Your Honor, the victim is on the Zoom hearing.
All right.
Ms. Newkirk.
Ms. Newkirk, do you wish to address the court? Ms. Newkirk? Don't think-
How you doing? I don't want to speak.
Okay. All right, thank you for your time. I'm going to order the $1,000 surety.
Your Honor, I haven't presented on behalf of my client.
I certainly apologize, Ms. McLeod. I'm sorry. Go ahead.
My client is 29 years old, Your Honor. She has absolutely no criminal history. She is the mother of a 6-year-old. She told me she was just to start a new job today, and this happened. She absolutely denies the allegations made by the prosecution. In fact, she tells me that what happens is that she is in a relationship with the complaining witness's sister, and they have been in a relationship for some time. The complaining witness does not approve of this relationship and has always been antagonistic towards her. The complaining witness came over to where my client lives, got into an altercation with my client, and tried to run her over with her car. And in the course of my client trying to get out of her way, this was when, her cell phone, she had it in her hand and it touched the car. She has no history, Your Honor, absolutely no violent history. Therefore, I think she's a good candidate for a signature bond.
In Your Honor,
I'm not quite done. I'm sorry. Yes, and I would ask the court to consider that, given the allegations made, which are unsubstantiated. She is presumed innocent. She's 29 and has absolutely no record. Thank you, Your Honor.
I apologize, Attorney McLeod, for that interruption. And Your Honor, we're just asking for the court to stay within the four corners of the warrant. The officer did not find probable cause for the allegations that Attorney McLeod stating that the victim attempted to run the defendant over with her vehicle. What the officer did find probable cause for was the fact that she busted her windshield, Your Honor. It was a violent offense, and we're asking for that $3,000 surety bond.
All right, I'm going to order the $3,000 signature bond through pretrial. And I'm going to order no drugs, alcohol, or weapons while on bond. I'm going to order a stay away from 2045 Allison Court Southwest.
He
Atlanta.
lives there, Your Honor. The alleged victim does not.
The victim does not?
No, Your Honor. She was visiting her aunt and her sister. She does not live there.
Can I say? I've been staying there for 6 years. That's my first apartment. Me and my kid. Valerie been staying at the top. She moved out and moved to Etheridge. Her baby sister and the girl that I was dating stay in the apartment. I still stay and rent my apartment.
Listen, let me speak for you. She doesn't live there, Your Honor.
Okay. All right, I will take off the stay away as long as the victim does not reside there.
That's correct, Your Honor. I just verified with my victim advocate, and she stated that the victim doesn't live there.
Okay, all right. Well, good. I'll take the stay away off, but I will order no further contact with the victim. And is it Miss Newkirk?
Yes.
Okay, no further contact with her. I don't, let's see, no drugs, alcohol, or weapons, and I guess that's it.
Okay.
Thank you, Your Honor.
All right,
Judge, you said through pretrial, correct?
3,000 signature
Through pretrial, correct?
to pretrial. Yes, I'm sorry.
Thank you.
Mhm.
Thank you, Your Honor.
All right.
12, Snyder.
Which position is this?
Position 12, Snyder.
12. This case number 22 CR 00570-3F. Justin Snyder, you're charged with giving false information to law enforcement officer. Offense date 8/25/2022. Pretrial.
His third arrest. Last was 2020 for felony obstruction. It was dismissed. 2014 misdemeanor possession of marijuana. Dismissed. That's it.
All right, Ms. Duncan.
Yes, Your Honor. This incident did occur yesterday. The incident date is 5455 Wynwood Parkway. And according to the facts, this defendant was approached by officers while inside of a vehicle at the Comfort Inn. The door was open and the defendant was unconscious at that time. And when the officers approached him and asked for his information, he gave officers the name of Jacob Snyder instead of his actual name, Justin, and a false birth date as well, the date of February 14th, 1993. Given that this defendant has limited history and no convictions, although he does have that prior arrest for obstruction in terms of not complying with officers, the state is going to be recommending a $500 signature bond through pretrial, no alcohol, drugs, and weapons, and no further violations of Georgia law. Nothing further from the state.
Okay.
Your Honor, I think he is qualified for $500 signature bond through jail. Nothing further, Your Honor.
All right. I'm going to order the $500 signature bond through jail. I'm going to order no drugs, alcohol, or weapons while on bond. and stay away from the 5455 Wynwood Parkway, the Comfort Inn. Please do not go back there, Mr. Snyder.
I'm currently staying there right
Please.
now. Oh, okay.
I will allow one-time law enforcement escort to retrieve any personal belongings, but you cannot stay there. All right, will that take care of that, Ms. Kim?
Yes, Your Honor.
All right, that's the ruling of the court. You're not to go there. Get a law enforcement to take you back to get your belongings.
Okay.
All right, we're done. Position 3, Bob.
Huh? This is 22 CR 005694B. Darius Ball, charged with 1 count of battery family violence. Offense date is 8/25/2022. Pretrial.
Get the rest. Last was 2014 trespass conviction. Before that was 2010 abandonment of dependent child. 2009 suspended license NOLO. And before that was in the 90s. That's it.
Okay. Ms. Tortorella.
Yes, Your Honor. For the battery family violence, we're asking for a $6,000 surety bond. The conditions is no contact with the victim. And the victim's name is Danielle Farrell. The first name is spelled DANNIELL. And the last name is F as in Frank, ERRELL. For the defendant to stay away from 1700 North Avenue in Atlanta. One-time escort, a 1-day anger management, no drugs or alcohol, no weapons, and no new violations of Georgia law. Your Honor, this incident occurred on August 25th, 2022 at the incident location 1700 North Avenue. This defendant poses a significant threat and danger to victim Danielle Farrell. When the officer arrived to the incident location, he immediately observed a visible injury on Miss Danielle Farrell's right eye, and it was leaking blood. The officer also observed the inside of the residence to be ransacked with items spread throughout. Miss Farrell advised she got into an argument with defendant Darius Ball regarding a male friend of hers. The defendant grabbed Miss Farrell and punched her in the face. Ms. Farrell advised the officer that the injury to her eye was due to defendant punching her in the face. Ms. Farrell advised that both parties lived together at the incident location. As far as risk of intimidation of the victim, Ms. Farrell was the 911 caller. She called the police because she was scared and needed help. When the officer arrived, he noticed Ms. Farrell was in a panicked state when she opened the front door. The officer also observed Ms. Farrell speaking in a low tone and pointing inside the home upon officer's arrival to assist the officer in locating the defendant. Ms. Farrell advised officers that she went into the closet in order to call 911. The defendant was arrested, and these events did occur in Fulton County, Georgia. Your Honor, this defendant has 5 cycles. The very last cycle is very remote, but what I see in his criminal history is a pattern of a criminal violation, and then a lapse of nothing, and then another criminal violation. So I'm going to go all the way back to 1997. He was arrested for simple assault, carrying a concealed weapon, and carrying a pistol without a license by the Atlanta Police Department. In 2010, he was arrested for abandonment of dependent child by the Fulton County Marshals. And recently, he was convicted in 2016 of criminal trespass, but the simple assault was dismissed, and this was in Cobb County State Court. For this reason, Your Honor, based on the facts of this matter, of this case, him posing a significant threat and danger to the victim, the risk of him intimidating the victim while out on bond, and his likelihood of reoffending while out on bond, we're asking for that $6,000 surety bond with the condition stated. Nothing further.
All right, Ms. McLeod?
Yes, Your Honor. My client is 44 years old. He is a native of Atlanta. He is the father of 3 children, 19, 14, and 7. The 7-year-old actually lives with him. I would like to point out, Your Honor, that my client does not have a violent history. He had a conviction, I believe, she said, in 1997. Other than that, he has nothing violent in his history. He certainly, it is a misrepresentation to suggest that he's in the habit of breaking the law. My client takes care of his 7-year-old. The 7-year-old actually lives with him, and she was in the house when the police came to the house, and he was there. Contrary to what the alleged victim has asserted, she does not live in this house. This is a house that is owned by my client. She is someone that he knows, and he's known her for a long time. He tells me that at one point in his life, he was homeless. And at that time, he knew her, and they have remained friends over the years. She called him and asked, could she come over to wash some clothes? She came over. She was asking him, could he take her to the train station? And he was feeling very sleepy. He told her no. So he was lying in his bed, and she came and she jumped on top of him and started to strike him. And, he got up, and I guess he must have headbutted her or something, but that's how she got her injured, because he was actually resting. He was in bed when this happened. He was shocked, he said, when the police just walked into the house, because he didn't even know she was calling the police, because she was the one who assaulted him. I believe that what his version of the events, Your Honor, is credible, and he is presumed innocent. I would ask the court to consider giving him a signature bond so he can get out and take care of his 7-year-old child who actually lives with him, Your Honor. He tells me he does have his own business, which he's had since he got back on his feet from being a homeless. He tells me that the house that he lives in is actually his home that his mom left for him in her will, and his name is on the deed, and this person does not live in this house. Thank you, Your Honor.
All right.
Your Honor, the victim did advise the police officer that they both live at the incident location. As far as defendant's habit of breaking the law, he does have 5 cycles, Your Honor, in his criminal history. And we're asking for the court to impose a no contact, Your Honor.
He's okay with the no contact with this person, but this is his home, and she does not live there. She came over asking him, could she wash some clothes?
Again, Your Honor, the officer stated in the warrant that she advised that she does live at the incident location.
Ms. McLeod, can you ask your client that one question?
Which is what, Your Honor?
Does the victim live there at that location?
No, she doesn't stay there. She don't have me.
Hold on now. What did your attorney to let you know whether you could answer that first?
Yeah, he can answer it, Your Honor, because that was one of the first things I asked him. And he advised me that she does not live there. He knew her from when she was homeless. And sometimes she comes and asks him, can she wash her clothes there? And he allows her to do that.
Is that true?
Yes, it was my mom's who passed 2 years ago. So therefore, she don't have any mail coming to my residence, and that's the only place that I have to go. As I stated, I was homeless a couple of years back. You see what I'm saying? So I was trying to see how would that work for me getting an eviction to get her out of my home.
Your attorney can advise you about that. The problem is I don't want there to be any incidents between the two of you. And it's interesting. I usually don't try to make a habit of putting the victim out of the location. But I know that you're telling me it's your mom's house that she left to you.
Your Honor, the defendant doesn't have any proof to provide the court that this is in fact true. And
they would not allow him to take the deed. I asked him about that.
Objection, Ms. McLeod, I'm still speaking.
Go ahead, Ms.
I'm sorry.
It's all right, Ms. McLeod. So I propose, Your Honor, that the defendant stay away, that he have a one-time escort to assure the victim has vacated the premises, and if so, that he may return. Otherwise, Your Honor, his defense can always file a motion to modify bond in the future.
Essentially, let us assume that what he's saying is true. He did a good deed for someone and he's supposed to be punished and put out of his home because of that. It just does not seem to be fair or right. He asserts that she does not live there and that he has a deed to this property.
Oh, sorry to be the third person to chime in, but whether he was doing a good deed or not, once someone live in your home for more than 30 days, they're considered a tenant. And your
Well,
client
she wasn't living there for more than 30 days. So she just came there to wash some clothes the day before the incident happened.
He said that she was staying there. I heard what he said earlier. So your client actually is correct. He would have to evict her, which is a separate legal process, separate from this action. But if she's lived longer than 30 days, it doesn't matter whose name the house is in. Legally, she's a tenant at will that has to be evicted, like was stated by your client earlier. So
I have files in Fulton County where I took out eviction and the marshals came out, but the police would not let me get my paperwork. My paperwork said,
like I said, that's a separate action. I can't advise you. Obviously, I'm the prosecutor, but that just goes to show that if he's filed the eviction notice, it was more than her washing her clothes there. Because if she was just washing her clothes there, he would have to file the eviction notice in the first place. So like I was saying previously, until she's been legally evicted, she's a tenant at will. And it doesn't matter if the name on the deed is his name, his mama's name, his grandmama's name, she's still legally a tenant until she's legally evicted. And it does not sound like that has happened based on one.
Well, my client told me that she does not live there. She just came there to wash her clothes.
Asking for the no contact order. And then if he wants to legally evict her, that will be up to him and you if you're willing to help. But that's separate from this action. She's still legally a tenant, and we're asking for the no contact because she's a stay away, and that's her legal address until she's legally evicted. And that's just the way the law works.
Right. I agree with the state. It's I'm going to issue a $6,000 signature bond through pretrial as is recommended. And I'm going to order the one-time escort back to that location with law enforcement to determine that the victim still lives there. If she still lives there, then he must go through the eviction process to get her out. He cannot reside there with her. That's going to cause him to end up back here at the Fulton County Jail. So there's no further contact with the victim, Danielle Farrell. But right now, the only way that he can stay there is if she does not reside there or he has completed an eviction process to get her out of that location. But he cannot stay there if when he goes back with police, they see her items there and she's still residing there. Is that clear?
Yes, Your Honor. Thank you.
Or Ms. McLeod, I'm sorry. So that's what I'll order. And I'm going to also order that one-day ankle awareness course through pretrial. Okay. So is there any other, I see your hand is still raised, Mr. Ball.
Mr. Ball, I advise you not to speak. I advise you to just exercise your right to remain silent.
Okay.
All right.
You'll have a signature bond through pretrial and you can call me as soon as you get out and we can have a conversation, okay?
Thank you, everybody. Enjoy the
Or you can call me from the jail.
All right. That'll conclude this case.
All right, going back to number 8, Mr. Herron.
All right. Are we ready for position 8?
Yes, Your Honor.
Yes, Your Honor.
All right, this is 22 CR 005699H. Derek Herron, you're charged with pedestrians listening rides are business and a second count of possession and use of drug-related objects both with the offense date of 8/25/2022. Free trial,
71 total.
7-1.
Yes.
Okay.
Between Georgia, North
Give me a little
Carolina.
bit. Give me a little bit, Georgia and
Oh,
what?
I am. Between Georgia, North Carolina, and South Carolina.
Okay.
Last arrest was back in May on probation violation. He's on probation for criminal damage to property. 21 SC 179-636. They gave him 3 years probation back in February. Hold on. Got a 2021 trespass family violence conviction out of DeKalb County. 2017 probation for shoplifting. 2017 possession of cocaine. 2017 probation shoplifting. 2015 FTA out of Gwinnett. This position was not prosecuted. He had a parole violation from 2015. Yeah, another one from 2015. I'll leave it at that.
Okay.
Your Honor, there is already a $1,000 surety bond in place, 500 on each count. The state is asking that that remain in place. Stay away from the incident location at 635 Lindbergh, and no alcohol, drugs, or weapons. This incident occurred on the 25th, yesterday. An officer was patrolling that area when he witnessed a male who was later identified as the defendant soliciting vehicles with a sign in his hand. And so the officer asked him for his name. The officer ran his name, and he saw that the defendant had a Fulton County warrant for the July FTA. And that is when he placed the defendant in custody, and based on the search incident to arrest, that's when he found the glass pipe on the defendant. Your Honor, you heard the history. I don't have to rehash that, but just based on the risk of reoffense and the FTAs, we have concern about him coming back to court. And so we are asking that $1,000 surety remain in place and nothing further.
All right. Ms. Gant?
Thank you, Your Honor. Mr. Derek Heron is 52 years old. He has been in the Atlanta, Georgia area since age 18. He does have family in Atlanta. However, none of his family members are able to help him with bond. Mr. Heron earned a GED. Currently, he is unemployed and has been so since the beginning of COVID back in March 2020. Your Honor, as you can see, my client is in a wheelchair. He informed me that he has severe muscle spasms and he also has a stroke. He's on medications to prevent the recurrence of a stroke. And we do have some concerns about whether or not he will be able to receive the proper medication while in custody. He denies the allegations. And in fact, he informed me that he was not soliciting anyone for anything. He states that while he is at this incident location, he was actually approached by a person who was donating clothes and shoes to the homeless. Officer saw this, approached him, and arrested him, Your Honor. I am requesting a signature bond. Clearly, he doesn't have the means to pay anything, and obviously there's a probation violation, so clearly he isn't going anywhere. So I would ask for a signature bond. If Your Honor determines that he is ineligible, then in the alternative, I would ask that you leave the bond as set. Currently, we are unopposed to the stay away. Thank you, Your Honor.
Okay, that 635, is it Lindbergh
That's correct, Your Honor.
Streetway?
It didn't say. I can look it up. Let me see.
And if that was a home, or is it just the middle of the street?
It was the middle of the street. So just no, I guess no loitering, no soliciting in that area. I don't know exactly what I believe it's Lindbergh Drive.
And that was probably just the closest address to.
Yes, probably.
To that location. So you all have not requested a stay away, or have you?
I did say to stay away from that incident location, Your Honor. We don't, like I said, I don't know exactly what. I think he was standing at a stoplight. That's what I assume.
Okay. Well, I'm going to order the $1,000 surety bond. And that'll be 500 on each. I'm going to order stay away from 635 Lindbergh Drive and no drugs, alcohol, or weapons while on bond. Anything else, council?
Nothing else, Your Honor. Thank you.
Nothing further, Your Honor. Thank you.
Okay.
Judge, next we have position 13, Spencer.
This is 22 CR 0005705Y. Kevin Spencer. You charged with 1 count of battery family violence on August 23rd, 2022. Pre-trial.
I have the history as well, Your Honor, if you'd like to continue.
All right, go ahead, Ms. Duncan.
Okay, Your Honor, I first want to state to the court that this case has been accepted by the DA's office as a felony battery family violence subsequent offense. With that being said, in this case, this defendant has 14 cycles going back to 2019. It is indicated in the GCIC that he is a multi-state offender, but I do not have that GCIC currently. This defendant has 4 convictions out of those 14 cycles. 3 of those convictions, Your Honor, are for violent offenses against this same victim in this case, which is a Russia Sabree, RUSSIA, last name SEBREE. He has 2 battery family violence convictions against this victim from 2020, that is 19 CR 008689C and 20 CR 001155C. In addition to a simple battery family violence conviction against this victim, in the case 20 CR 00620446D. Your Honor, in this case, the state is going to be requesting a $20,000 cash only bond. This defendant has 6 open cases, and of those 6 open cases between state court and Fulton Superior Court, 3 of those cases involve the victim in this case. The first open case is 21 CR 004268Y. That is a simple battery family violence where this defendant received a $5,000 good bond and was told to not have any further contact with the victim in this case and to stay away from the incident location of today's incident, which is 2257 Bigwood Trail. In addition to that, since being released from that simple battery family violence, this defendant has reoffended in 3 ways in a violent manner. It's indicated by prior contact with this defendant that case was the 6th time he had been violent against her. In addition to that, he went to felony first appearance this morning, Your Honor, for a burglary against this victim, 22 CP 211792, and a battery family violence against this same victim. That is 22 CP 211793. In this incident, Your Honor, officers arrived at their location and they met with the victim in this case, and was indicated to officers that the defendant had punched her in the face multiple times and she had visible injuries, including a bloody lip and a swollen face. As I stated before, this case has been accepted for transfer, and the state is asking that the court give a recommendation in light of the fact that this is a felony offense. In addition to that, this defendant is subject to a TPO according to contact with the victim previously. It was taken out on August 31st, 2021. It was ex parte for 12 months. Therefore, this defendant has offended 3 times violently against this victim since receiving service of the TPO. She stated to us previously that she has a strong fear for her life because this defendant does not follow no contact orders. He doesn't regard the law in any type of way. She's afraid that he's going to get out and to retaliate. She says that when he's in jail, he calls and he sends her letters with other inmates' names. He calls her with the bonding companies, telling her she needs to bail him out because it's her fault. And several other things, Your Honor. So in this case, the state has a concern about the risk of reoffense, as we think it's obvious given the history, the intimidation factor for this particular victim, and the danger to this particular victim. And she says that she has children. We're unaware of the status of those children, and she says that she wants to protect them as well. We also have a flight risk here because he does have an FTA arrest from 2022, as well as this defendant is likely to not respond to legal process, given the fact that he's been subject to several no contact orders and a TPO, and has continued to violate over the years in regards to this this victim, and majority of his history is violence against her. So we're asking for the court's help in protecting this victim, and we'd like to have that $20,000 cash only bond, no further contact with the victim, Russia's debris. If they share the children, we'd ask for no contact with them as well, and stay away from the incident location, no alcohol, drugs, and weapons, and no further violations of Georgia law along with FFIP. Nothing further from the state.
I haven't been around our address since December.
Mr. Spencer, you have a right to remain silent, please.
Anything I want to say is going to be for my help. It's not going to be to hurt me. Okay, Russia is a liar. Russia has alcohol problems. Russia has hallucination. Russia has things y'all do not know about this lady versus her style of report.
Your Honor.
Quiet, Mr. Snyder, please. It is not for you to speak. Please be quiet.
But it's not true.
You're not helping your case. This is not your trial.
I'm taking a lot of convictions for nothing though. All right.
This is not your trial. This is your bond hearing. And if you don't be quiet, I'll just let you sit there for a while. And we'll end your hearing. All
Okay.
right.
Mr. Kevin Spencer is 36 years old, Your Honor. He has been here in Georgia for about 5 years. Well, his father is here, I guess, and because of his disability, Your Honor, he has not been able to work last 6 months. So he does not have any financial means to make a payment for this bond. And also, Your Honor, his education is, he graduated from high school, and we would like to request for maximum $2,000 good bond, or, I mean, not the cash bond, absolutely not the cash bond, Your Honor. So, yes, that's it. And also, we have no objection to stay away because he does not live there. They do not reside together. Their relationship has been broken up, and he does not mind no further contact either. Thank you, Your Honor.
Your Honor, if I may, just to the defendant's point, in that burglary case, there's evidence of the defendant on video committing that offense on June 20th, 2022.
Your Honor,
nothing further from the state.
We have not seen that video, and I don't think that should be considered here, Your Honor. Objection for that.
Excuse me.
Mr. Kevin, please.
Russia's supposed to be on here today. Miss Kim, did you talk to Russia, Miss Kim?
Can you unmute Mr. Spencer?
And I'm not sure how he knows that Russia's supposed to be on here today if he hasn't spoken to Russia, but I
can kind of agree with you on that, Mr. Walker.
And he's on a no contact order from all of these cases, Your Honor.
Right. It's obvious. I don't think she's on here. I don't see.
We were not able to make contact, Your Honor.
Okay. And I don't see her listed here on the Zoom.
I was not able to make contact with her either. I called and the answering machine was in Spanish, so I couldn't understand.
Okay. All right. Given the conduct I've seen from Mr. Spencer thus far today, and I understand what his bond is from his felony court earlier today, and the repeat offenses against this victim here. I'm going to order the $20,000 cash bond. And I'm going to order no drugs, alcohol, or weapons while on bond. Stay away from 2257's Brickwood Trail.
Bigwood, Bigwood.
I'm sorry, Bigwood. And I'm going to also order no further contact with Russia Sabri. And I think that would be no drugs, alcohol, or weapons while on bond.
Yes, and the order for transfer has been submitted for your signature.
All right, thank you.
Thank you, Your Honor.
Uh-huh.
Hey, what was that?
$20,000 cash bond.
And
Mr. Dennis Spencer, you have a right to remain silent. Please do not hurt your case anymore.
all right, so are you gonna be
ruled?
Ms.
I'll call you, please.
I got a question. It's not
Okay. Let's go, and then I'll call you, and you can ask me all the questions, please.
All right.
Thank you.
Position 11, Sanders.
$22 CR00. Oops. Let me see. There we go. 22 CR005702J. Nigel Sanders, you're charged with 1 count of battery and a 2nd count of possession and use of drug-related objects. The offense date is 8/25/2022. Pretrial.
18 total. Last arrest for 2017, simple battery, family violence. On probation for aggravated assault, 12 SC 114363. 2013, they gave him 30 months confinement, 17 years and 6 months of probation. 2017, simple battery DV conviction. 2010, criminal damage to property, 2nd degree. Theft by taking, possession of tools conviction. 2012 assault. 2007, criminal damage, 2nd degree, burglary, possession of tools conviction. Before that was 02, possession of tools and damage to property. That's it.
All right, Ms. Duncan.
Yes, Your Honor. In this case, it occurred at a BP gas station located at 2261 Cascade Road Southwest. There's a preset bond in this case of $3,500 surety. The breakdown is $3,000 for the battery and $500 surety for the possession of drug-related objects. The state is going to be asking that bond remain as set. In this case, we have a concern about the risk of reoffense, given this defendant's history of violent offenses and convictions. In this particular incident, the defendant is seen at this location punching the victim in this case, which is Mr. Gilbert Howard, both common spelling, in the face several times with a closed fist, as well as slamming him on top of trash cans at that location. Officers did observe visible injuries to this victim in the form of 2 knots in the front of his head, and I believe 2 knots in the back of his head from the encounter with the defendant in this case. So we also have an additional concern for the physical safety of this particular victim. All of these incidences are alleged to have occurred and were recorded on the surveillance camera at the location of the BP. Nothing further, well, in addition to that, no further contact with the victim, a stay away from that BP, and 4 weeks of anger management. Nothing further from the state.
Okay.
This is conflict case, Your Honor. I believe Mr. McLeod is on the way.
Turn on your camera, Ms. Kim.
It's not my case, Your Honor.
Oh.
This is conflict case.
Oh, okay. Ms. McLeod.
Yes, Your Honor, I'm sorry.
Go ahead. This is position 11, Mr. Sanders.
Mr. Sanders, I don't think.
Nigel Sanders.
Mr. Sanders is my client.
No?
Oh, yes, yes, Your Honor. Yes, Mr. Sanders. I'm sorry. Yes, Your Honor.
All right, you may go ahead.
Your Honor, Mr. Sanders is 60 years old. He tells me that based on what the complaining witness has alleged, that he is now homeless. He had been homeless prior to that. He just started working, and in the position that he was working at, he actually had some kind of accommodation on the site. He denies the allegations that he attacked this person. He said what happened was that the complaining witness went and told his employer something that was totally untrue, and that was the reason that they got into an argument. And he was attacked by the complaining witness, and he simply fought back. He only has an 8th grade education, Your Honor. He doesn't have any children, he tells me, doesn't have a spouse, doesn't have anyone to help him make bond. And going forward, because of this incident, he's going to be homeless. So I would ask the court to take that into consideration in setting his bond. Thank you, Your Honor.
And just as previously stated, these incidences were captured on surveillance camera that the officers viewed upon making a determination of probable cause. Nothing further.
All right, I'm going to order the $3,500 surety bond, $3,000 on the first, $500 on the second charge. Gonna order a stay away from 2261 Cascade Road Southwest, which is at the BP gas station.
Yes.
I'm gonna order no drugs, alcohol, or weapons while on bond. And I think that's it. Anything else I need to take up, counsel?
Is the court willing to impose anger management?
Well, I don't know if he'll be able to pay for it.
He doesn't have the means to pay for anger management, Your Honor.
Okay. I'll leave that off for now.
Understood, Your Honor.
All right, that will be it.
Thank you.
Position 4, Dickerson.
Yeah.
This is 22. This is 22 CR 005695D. Sherrod Dickerson, charged with 1 count of criminal trespass. The offense date is 8/25/2022. Retrial.
14 total. Last arrest was in April. Obstruction, possession of cocaine. Let me try to follow this for a minute. 22 CP 208248. I also have an open 21 CP 205051 for obstruction, trespass, possession of drug-related objects, possession of a controlled substance. Was arrested in January on a probation violation out of Oconee County. December 2021, that's the trespass, obstruction, controlled substance. September 2021, probation out of Oconee. Also a shoplifting arrest. 2021, failure to appear out of Oconee. 2021, FTA shoplifting out of Dunwoody. October 2020, shoplifting. Possession of drug-related objects conviction from 2019. That's it.
Okay. Ms. Tortello.
Yes, Your Honor. For the criminal trespass, the state's asking for the $5,000 surety bond to remain the same. The conditions is for the defendant to stay away from the incident location, the Ashton Brown Mills Apartments at 500 Cleveland Avenue Southeast in Atlanta. No drugs or alcohol, no weapons, and no new violations of Georgia law. Your Honor, this incident occurred on August 25th, 2022 at 500 Cleveland Avenue Southeast. This defendant poses a risk of reoffending. He also poses a significant threat and danger to property of Ashton Brown's Mills Apartments. Defendant Jared Dickerson returned to Ashton Brown Mills Apartments after being issued a criminal trespass warning on July 6, 2022 by the Atlanta Police Department. For the record, that's case number 2218-70610, which ordered the defendant not to return to the incident location. Property manager Sherry Abernathy of the Ashton Brown Mills Apartments stated the complex is a senior living facility, and some residents have complained of defendant being on the property and damaging the side and back door to the property. The officer observed the defendant smoking a cigarette and was arrested at the scene. And all these events occurred in Fulton County, Georgia. Your Honor, risk of reoffending and committing felonies and violating bond orders, this defendant fits this list. He has two open cases, 22 CP 208248, arrested for VGCSA, loitering, obstruction, and drug objects. The offense date and filing date was on April 13th, 2022. He received a $2,500 surety bond, and he violated his bond order as it is implied by Georgia law that you not violate any laws of the state while out on bond. The second felony case, Your Honor, is 21 CP 205051. Again, he was arrested for VGCSA, drug objects, criminal trespass, and obstruction. The offense date and filing date was December 8th, 2021. He received a $3,000 surety bond. And again, he violated this bond order as it is implied by Georgia law that you not violate any laws or ordinances of this state while out on bond. Your Honor, he has 14 cycles, as you've heard from pre-trial. He pled just last year, May 5th, 2021, for possession of meth out of Oconee County Superior Court. He possibly has an open case out of Clayton County. He was arrested on April 13th, 2022 for possession of cocaine by the College Park Police Department. I looked in our system, Your Honor, and this case is not in our system. On January 6, 2022, he was arrested for unlawful guard lines to deliver a controlled substance out of Oconee County's Sheriff's Office. And he has various shoplifting arrests from last year, and in 2020, he has one out of Dunwoody. Violations of probation, as you heard from pretrial, he has several, and he has several FTAs on his record. So for this reason, the $5,000 surety bond should remain as set with the conditions already stated. Nothing further.
All right. And what was the victim's name again?
It's an apartment complex, Your Honor. It's the Ashton Brown Mills Apartments. Do you need the spelling, Your Honor?
No, I have it.
Okay.
All right. Ms. Gant.
Thank you, Your Honor. Mr. Gerard Dickerson is 30 years old. He has been in the Atlanta, Georgia area for over 10 years. He does have family in this area, Your Honor. However, they are unable to offer any assistance toward bond. We are unopposed to the stay away at the incident location. My client has no reason to return there. He does not need a one-time law enforcement escort. Mr. Dickerson completed high school. He also has a bachelor's degree in information technology. He plans to return to college at the earliest opportunity. Currently, he is employed as an Uber driver full-time. He has only been in that position for 2 months, and Your Honor, prior to that, he had been unemployed for about 1 year. Therefore, he really doesn't have the means to pay anything toward bond. Your Honor, my client is presumed innocent at this point. He's presumed innocent in this open case as well as any other open cases. Your Honor should not rely on any possible open cases from Clayton County. The state certainly doesn't have any proof of that, nor does the defense. Lastly, Your Honor, this is a criminal trespass charge. He did not offer, there is no allegation that he offered violence. So I believe that the state's contention that he's a threat to the residents there is just totally unfounded. I am requesting a signature bond on Mr. Dickerson's behalf. That's basically the only way that he will be able to get out of jail. Bond should not be punitive. And if Your Honor determines that He's ineligible for a signature bond. I would ask for a bond reduction, a bond of no more than $1,000. And again, we are unopposed to the stay away. Thank you, Your Honor.
Okay. I'm going to reduce the bond to $4,000 surety bond on that criminal trespass to stay away from the apartment complex Ashton Brown Mills. No drugs, alcohol, or weapons while on bond. And I think that's it. Anything else you take up, counsel?
Nothing further. Thank you, Your Honor.
Wait, hold on, man.
Mr. Dickerson, if you're speaking, I do advise you to remain silent. If you have any questions or concerns, I'll call you at the jail.
I don't have $4,000. I mean,
We've made your bond argument. The judge has ruled. I'll give you a call.
Can I get a serious bond at least? I mean, that's all I have.
Your Honor, I do apologize for the interruption.
It's okay. No signature bond, it's a surety bond.
Your Honor, what was that amount again, Your Honor? I apologize.
$1,000.
1,000?
Four.
Okay.
Judge, the last case we had was position 14 and they waived their appearance and we're completed here in courtroom 2, Judge.
What happened with Goldston?
Yes, what happened to 5? Is it Gloston? Willie Gloston fourth?
Oh, he waived his appearance?
Yeah.
Okay, position 5 also waived their appearance, Judge.
Yes, Your Honor, Ms. Gluston did. Your Honor, Mr. Gluston had informed me that he was interested in the plea, but I hadn't had a chance to discuss any offers with the prosecution. I have now, Your Honor, and they have made an offer, I think.
Okay.
Yes, Your Honor, we understand the defendant has currently just pled to a Superior Court case. And I can give you that case number and we'll be running that. He's on a 10-year sentence, so we'll be running that concurrent. And it'll be 12 months to serve for the battery.
Okay.
Which would run concurrent. I had discussed it with him, Your Honor, and he had expressed an interest in doing that.
Okay, so do
We
you?
will need the paperwork sent to the jail if he's gonna
Yes.
take a plea.
Yes.
Okay.
Right, I mean, we'd have to see if we could do that or either reset him for Monday to do that.
If we can get a hold of him today, I can go ahead and just do the paperwork.
Okay.
And send it to Ms. McLeod.
That would be fine. I'll be working. And Your Honor, I apologize to Mrs. Sanders. What happened that I was trying to talk to the jail, trying to talk to ASG, Tortorella, all at the same time. And
Everybody together, we understand. All right, so we have, this is Larry Thompson.
All right, Judge, we're completed here in courtroom 2.
Oh, that's right, you said Larry Thompson waived.
Yes, we're completed. Thank you.
All right, thank you. Have a good weekend.
Thank you. You do the same.
So let me get some clarity. Are we gonna go ahead and take the plea on number 5 today, or is he gonna be reset? Mr. Boston. Position number 5.
My understanding is that we're trying to do it today, so he doesn't have to
Okay.
be reset.
As well.
But if he waived,
Okay,
is he
so you
coming
want me
out?
to send the paperwork?
The jail, is the jail gonna get him? Is he coming out? Is he gonna waive his appearance?
Yeah, that's
He
because that's
told
gonna
me
be
earlier
waived.
when we spoke that he wanted to waive his appearance, Your Honor.
I've not taken a plea without appearance.
Right. You know, I did tell him that if he was going to take the plea, if there was an offer, then he would have to come over, because that was my understanding too, that he would have to be here.
I don't have a court reporter.
So we can't.
Nope, I can't take it today. We can reset him for Monday and see if you all can get someone to do.
Well, we'll
plea
have
on
court
Monday.
tomorrow. We have
Yeah,
a
there
C
is court
calendar
tomorrow, and
tomorrow.
I could make myself available to do it tomorrow.
Well, yeah, you can do it tomorrow at C tomorrow.
Is this gonna be a extra time plea or is it a time served plea?
I don't know
Sorry?
go ahead, I'm sorry.
I didn't hear what, somebody said
Is it a
something. and I
time
didn't-
served plea or is it additional jail time? Well, he's gonna be there because it's running concurrent with
Yes,
the
it's
other.
running concurrent with his 10-year. I understand that he's gonna be serving 10 years.
Yeah, it's not a time served plea, it's a 12 months to serve.
Yes.
And it's gonna run concurrent to the Superior Court case that he has.
For the 10 years.
So we don't have
Court reporter.
court reporters on Saturdays. So you may want to do his bond hearing and then just put him on the SAP calendar for the plea.
I mean, I would agree. I mean, if he's going to be serving a 10-year sentence, I don't quite see the rush.
Right.
True, I have to agree.
I mean,
I
that's
think,
trying to be
Mr.
funny.
Walker, you and I actually agree on that one.
Right. Okay, Mr. Walker.
So with that being said, we'll set him on the calendar for Monday.
Yeah,
No,
that should be
Tuesday,
available
yeah.
on Monday.
Well, oh,
Okay.
I was
Well,
going to
I would
recommend that
actually-
because, go ahead, I'm
I
sorry.
would actually prefer that we just put it on an SAP
right,
calendar.
that's what I was gonna say, Tuesday.
That's
SAP.
also fine. Hopefully I'll be
I
available.
mean, we will
Okay.
take a plea on first appearances, but
They don't like
I
to do
think the more
that.
appropriate thing to do is to put it on
I
an
know, and this is the first time, but once we had our discussion and I saw that he was going to be a guest of the state for 10 years, I thought
Right.
it made sense to just dispose of everything.
Right. But let's, can we set him for Tuesday, Ms. Bridgewater or Mr. Jordan? For SAP?
I mean, I could put him on. Mr. Jordan?
That's not a problem, Judge. So does he have a bond on his case?
We haven't even discussed that yet, you see, because
Because we're
once
gonna
I
be
talked to him-
in dispossessory court, Mr. Walker, so that's why I was saying that. I'm making fun of you, Mr. Walker.
Whose position
I
is
can-
this, Judge?
I mean, we can set a bond, but if he's serving, I think we do need to set a bond.
We do.
And
He already-
it doesn't
he already-
matter.
I'm sorry.
already has a bond?
He has a $3,000 surety bond.
Oh,
Okay.
okay.
So if we can do an add-on for Tuesday, we'll just knock it out then and be finished. I think that'd be the best thing.
We can reset him for, that'll be the 30th.
Yes, I think, let's look at my calendar.
So I can say for the record that we will continue with his $3,000 surety bond. And then he's reset to September 30th as an add-on to the SAP for a plea.
Wait,
Yeah.
Okay,
did you mean August
30th, I'm
30th?
free.
What was that, Mr. Walker?
Did you mean August 30th?
Oh, what did I say?
August 30th,
September,
yes,
I'm
that's
sorry.
Tuesday. Yes.
August 30th, I apologize.
And would that be 9 o'clock? I'm good at that time.
Yes,
Yeah.
It's in my calendar.
yeah, that's 9 a.m.
And what I'm gonna do, Attorney McLeod, is send you the offer formally via
That would be
email
good.
from the
Yes.
state, and I'm gonna CC Mr. Walker and Deputy Falk, so they're aware.
Okay, awesome.
Everybody's on
Sounds
the
good.
same page.
Thank
Okay,
you.
that sounds
Right.
great. Thank
All
you.
right.
And then
We have this one
do the
waiver.
last one, Larry
District Court.
Thompson. Yes. This is case number 22 CR 005704A, Larry Thompson. Willful obstruction of a law enforcement officer and possession and use of drug-related objects. Offense date, August 25th, 2022. Defendant has waived his appearance. What do you have pretrial?
78 total,
7-8?
correct. Last arrest was in April. Shoplifting obstruction. 2020 parole violation. 2019 trespass damage. 2019 failure to appear. 2016 shoplifting. 2015 FTA. I'll leave it at that.
All right. Mrs. Duncan?
Yes, Your Honor, this incident occurred in the area of 371 Boulevard Northeast in Atlanta on yesterday. Officers noticed the defendant in this case violating a city ordinance, so they stopped the defendant to ask him for his identifying information. However, the defendant refused to answer any questions from the officers, provided a name, but would not refuse to provide a date of birth, and additionally sat down on the curb instead of responding to officers' requests to stand up when placed under arrest. After being arrested in the pat down, officers recovered a burnt glass pipe in his pocket. Given the facts and circumstances in this case, this defendant does have 79 cycles going back to 1990. He is a convicted felon, and in the last 10 years, he's had 20 cycles, which do include FTA no-low pleas, as well as an arrest for obstruction in 2014 and an FTA in 2015. Subsequently, those were not prosecuted. However, they do show a pattern of behavior, as well as a parole violation in 2020 and an obstruction from April 2022 out of Brookhaven. Given those facts, Your Honor, there is a preset bond in this case of $1,000 surety. However, the state is going to be requesting that $1,000 surety be increased to a $1,500 surety. That's $1,000 surety for the willful obstruction and $500 surety for the possession of drug-related objects. Given this defendant's history, we have the concern about risk of reoffense and a flight risk, given that there are recent FTAs. Nothing further from the state.
All right. Ms. Kim?
Yes, Your Honor. Mr. Thompson is 49 years old, and he has been here in Georgia for all his life. He has 3 adult children, and he has he does not have any job right now. He's unemployed, and his highest education level is GED. At this point, he is residentially challenged. So I would like to request I am actually recommending for social worker services to visit him and to give him housing resources. We would like to request for a signature on bond. And yet, if Your Honor is not inclined to give him a signature on bond because of his 78 cycles, I had a hiccup because it was kind of like, but anyway, we would like to ask the court to have $1,000 as set, which is already set there, 500 each, Your Honor. Thank you.
Okay. I'm going to enter a surety bond and increase it to 1,500. Surety bond 1,000 on the obstruction and 500 on the possession and use of the drug-related objects. Total of 1,500 surety bond, no drugs, alcohol, or weapons while on bond. And is there anything else? Because there's no stay away or no victim, right?
Nothing further from the state, just no further violations of Georgia law.
Okay. No further violations of Georgia law. Sounds good.
Thank you, Your Honor.
All right.
Thank you.
Thank you.
Yes.
Are we ready to go over the
Yes,
calendar?
we are.
Okay.
Okay.
Once again, the reset date for the SAP calendar is going to be September the 8th. Position number 1 is reset further notice with a $3,000 SOB through pretrial. Position 2 is going to the SAP calendar with a $4,500 good bond. Position 3 reset further notice with a $6,000 SOB through pretrial. Position 4 is going to the SAP calendar with a $4,000 good bond. Position 5 is going to be reset to the SAP calendar on Tuesday, August 30th with a $3,000 good bond. Position 6 is going to the SAP calendar on September 8th with a $2,000 total good bond. Position 7 is going to the SAP calendar with a $2,500 good bond. Position 8 is going to the SAP calendar with a $1,000 total good bond. Position 9 is going to the SAP calendar with a $5,000 good bond. Position 10 is going to the SAP calendar with a $3,000 total good bond. Position 11 is going to the SAP calendar with a $3,500 total good bond. Position 12 is reset further notice with a $500 SOB through the jail. Position 13 is going to the SAP calendar with a $20,000 cash only bond. And position number 14 is reset to the SAP calendar with a $1,500 total good bond. Are there any questions, comments, or otherwise?
Position 13 has been transferred to the DA's office.
Okay, but he still has a $20,000 cash bond.
Yes.
Okay, got it.
And
Any others?
no questions about the bond and conditions, but I would ask that Mr. Jordan please check the chat for my request for an interpreter at the SAP hearing on September 8th for position 8.
Okay. I will make sure he gets that.
Thank you.
Ms. Duncan has sent over the transfer as well.
Okay. I'll make sure we get that and have that request for the interpreter. Are there any others?
No.
If not,
Oh,
if not, let the weekend
Mr.
begin.
Walker say, hold the press. What did you say, Mr. Walker?
I just said happy Friday, everyone.
Yes, let the
Thank you.
weekend begin.
Have a good
Take care,
weekend.
everybody. Be
Bye,
safe.
everyone.
Bye-bye.
Bye-bye.